I'm just going through a few of the things. So I think many companies started to take steps, I would say, before there were official obligations, for employers to comply with. Obviously, there's always been a duty on an employer to safeguard health and safety and to take steps to make sure that the work environment is a safe place for employees. And that prompted many employers to, from about the beginning to mid-March, to take steps such as telling people if you are a high-risk category, for example, you're an asthmatic, you have a chronic underlying health problem, you have an autoimmune disease, or you're sort of in the elderly category over the age of 50, then you were encouraged to work from home. And actually in the government sector, the UAE government put in place those kind of directives quite early on towards the beginning of March. It then sort of cascaded through various things about health and safety, social distancing at work, and a little bit of a soft approach of employers doing it as part of corporate policy and in terms of, I guess, the sort of health and safety obligations. And we started to see, employees getting tested, having to do self-imposed quarantine because they'd maybe traveled in their spare time to a high-risk destination or even for business and so on. And I think what really started to happen towards the second half of March, it sort of got obviously much more serious. So Emirates and Etihad suspended commercial flights. The UAE effectively closed its borders. And then on the 29th of March, the Ministry of HR and Emiratization issued 3 new resolutions. One is to do really with stabilizing the workforce for Emirati nationals, so UAE citizens. And that really involves the formation of a special committee. They are charged with reviewing opportunities for work in the private sector for nationals, reviewing why it is that nationals have left employment in the private sector, so reviewing things like exit interview minutes and so on, and then making internal recommendations for what the ministry might want to do to encourage employment in the private sector. The 2 immediately key resolutions and sort of immediately very relevant in terms of obligations and what we have to do as employers are resolutions 279 and 280 of both of 2020 and both published on the 29th of March. The first one obliges employers to only have 30% of their workforce in the office. And so 70% of the workforce has to work from home. And the 30% that are in the office, the employer has to put in a system where they can monitor temperatures twice a day. Obviously, if somebody displays COVID symptoms or their temperature is high, then they have to be sent to a doctor to get medical treatment or a sort of okay that they are healthy to come to work. And they are not, the employer is under an obligation not to let them back in the office until they do get that sign off. And also at work, employers have to exercise social distancing and take measures in that regard, have signage as to, what is COVID, what steps can you do to avoid infection and so on. Have additional sanitizer, additional soap, all of these kind of things, and masks for people to wear in the office. Now, there are some sectors which are exempt. So sectors which are viewed as sort of vital at this period of time or vital support. So, for example, critical infrastructure, communications, banks, so services, food, supply chains, healthcare in terms of all the medical clinics and the hospitals and their supply chains. So all of those are exempt. They can have 100% of their people at work if necessary. Now, in line with the health and safety issue, if somebody can do their work from home, then an employer really should be putting that in place and putting arrangements for that. The other big step that was taken was resolution, the second resolution, and that is really recognizing that COVID-19 has caused, in real terms, a cash flow problem, a bit of economic hardship, and many businesses are suffering. And so this resolution talks about employers implementing on a gradual basis a number of measures. So they can ask employees to go on paid leave, ask employees to go on unpaid leave, to accept a reduced salary for a period of time, the suggestion being that it would be for 3 to 6 months, or finally ask employees to accept a permanent reduction in salary. And so that is really a very big message to employers and also to employees, that the government has recognized that there is an economic impact to COVID.
Absolutely, and that's a great segue into the first part of today's webinar. So let's get into pay reduction, paid and unpaid leave. You've mentioned that the new resolution makes it possible for employers to take gradual steps. Paid leave, is it at this point in time legal for employers to ask their employees to be on paid leave, to go to unpaid leave?
So the resolution talks about on a staggered basis, and the first option is to ask people to go on paid leave. So if anyone has accrued leave for this year, for example, they've got 6 days that they haven't used, then employers as a first measure are encouraged to put people on paid leave. So let them, just so that they don't suffer any loss, let them go on paid leave first and then move to unpaid. There isn't any, so whilst I think the resolution sort of assumes that that's what will, the sort of sequence of measures, that's what will happen, it doesn't say that an employer must. It does talk about gradual implementation of these kind of measures in terms of seriousness and impact on the employee. But there isn't any hard and fast rule that they absolutely must do one before the other.
All right, so then is it legal, so then it's okay for employers to require their employees to go on unpaid leave, even if they still have paid leave balance?
Yes, there's no prohibition on doing that, yeah.
Is there a limit as to how long we can ask people to be on unpaid leave?
There isn't a limit on how long you can agree with an employee to be on unpaid leave. And interestingly, after this resolution, there's also been a sort of protocol for asking employees to take leave, and that is that if Emirates and Etihad have started to run some flights on the 6th of April, provided an employee could use one of these flights to go home, there's a protocol of asking your employee to actually go outside of the country for a while, be on unpaid leave. You do have to give them a return ticket, and obviously they're still an employee during that time. It's just that they don't need to be here, they don't need to work, and therefore they won't be paid.
Okay, so I think you said something really key here, and you said you have to agree with your employees to take paid leave. What if employees don't agree, and how do you need to kind of formalize this agreement?
Yeah, so alongside the resolution, the Ministry has also published an addendum. If the arrangement is going to be on a temporary basis, then strictly speaking, the addendum doesn't have to get registered with the Ministry. If it is, for example, a permanent reduction, then you do have to go to a Tasheel Centre, submit the addendum and register, because it's going to be a permanent amendment to someone's contract. I suppose, as a matter of contract, employees do have to agree these with their employers. But it would be, I think in this climate, I have to say, I think it would be a very brave employee who didn't enter into at least some negotiations with their employer about what measures could be taken. Because from a practical perspective, if you as an employer you have, for example, 70 employees, and you decide because of cash flow problems and the economic impact that everybody has to take a 15% or 20% reduction, or you implement it, which a lot of employers are doing according to seniority. So the higher paid people take a bigger cut, and the more modestly paid people are sort of asked to take a smaller cut. I think as an employee, if you're not going to respond positively to that, you are then opening the door for the employer to have quite a serious discussion about whether even terminating employment is an option. Because these kind of measures really only work if everybody is gonna sign up to them. It wouldn't make sense, for example, for everybody out of 70 for 65 people to say yes, we'll accept a pay cut, and 5 people to say no, we won't. You can't. You sort of everybody does, or it doesn't really work.
So we're getting a lot of questions right now around this question of agreement. So sorry, the questions are moving really fast. Amit is saying, what if the employee refuses refuses or does not give consent to the salary cut? Is that deemed as insubordination? So I think that goes back to what you were just saying, Sarah, right? It would be challenging for an employee to refuse. It's obviously best in the interest of employee relations, and because of the duty of care that you have as employer to your employees to sign an agreement. But we're also getting a few follow-up questions on this, saying if the employee refuses to take a pay cut, can we? Sorry, your questions are going really fast. I'm trying to put up. If the employee refuses to take a pay cut, can we terminate them?
Can you terminate them? You could potentially look at termination, yes, because you've tried to take a measure short of termination and they've not agreed to it. The only thing I suppose there is if the business is facing cash flow problems, if you terminate, you would be termination on notice, and they would be then entitled to receive their end of service gratuity. So yes, and I think arguably if everybody has been asked to to do something for the business so that it's sustainable, that is potentially a fair dismissal. And I think the resolution that the ministry published on the 29th of March really gives a lot of employers support in saying this is if you don't accept this is a fair decision to dismiss. Mm-hmm. And of course, actually, one thing to say with the dismissal, the labour law hasn't been amended, so if you do dismiss somebody, the potential liability or damage is the same as it has always been. It's 3 months compensation for the termination.
Great. So we'll get into termination gradually. Before we get into this, let's speak about salary reductions. So are there any regulations around these salary reductions? Is there a maximum percentage that we can ask employees to take a cut off? And what about, does it apply to people who are perhaps in probation period or a notice period? Does it differ depending on the contracts that they're on, the types of contract that they're on?
Yeah. So in terms of the sort of resolution, it doesn't give the detail of reduction. It simply says that it's something that you can agree. I think as an employer, when you're looking at it, though, there are a few things that you would want to think about. So as we all know, end of service gratuity is in the UAE is on basic salary. So in terms of trying to minimize the impact on employees, you, if this works, could think about reducing allowances and keeping the basic salary as it is. Excuse me. And so then that impact is diminished for employees, and it may make them feel a lot more comfortable. The other thing is, if the reduction is going to be on a temporary basis, what you can agree with employees is, so for the next 3, maybe 6 months, we will pay you 20% less, but we'll keep the gratuity accrued at the same level. So just by way of example, you're paid something like 30,000 before we reduce pay. We then reduce pay for 3 to 6 months. After 6 months, we increase the pay, and the gratuity stays the same because you're still accruing it on the higher level. So there's a few things that really are worth thinking about.
So I remember in the first webinar that we did with your colleague Sarah, we discussed the possibility of a ring fence the gratuity that had been accumulated until then, and so obviously this would have to be documented in writing.
I'm really sorry, Charlotte, you're breaking up. I didn't quite get that.
Yes. When it comes to gratuity, how can employers ring-fence the gratuity that has been accumulated until then to kind of protect the employees? We can imagine that a lot of employees wouldn't just rely on trust for their salaries to go back up so that they can take up the gratuity.
I can't hear you.
Just,
sorry, maybe you could type it quickly. Yeah, that really broke up.
All right. Yeah.
Oh, I've got a question here. Should I answer this? Can the salary be reduced during notice period?
Hold on. Sorry, everyone. I think Sarah's having issues hearing me. I'm just going to type up the questions for her. Make this work.
So gratuity is calculated on the last salary. How can employers ring fence the gratuity that's been accumulated until then? So if the salary reduction is going to be permanent, and let's say, and these are discussions I know are happening in a lot of businesses of, well, from the 1st of April, we'll apply a reduction, or from the 1st of May. What an employer really, to do it all correctly, is that gratuity up until, in my example, the 1st of May, should be calculated according to, let's say, the higher salary or the normal salary. And then it should be ring fenced. And then after the 1st of May, you calculate gratuity on the lower salary. Now, obviously, if somebody, all being well, then stays with the business for a longer period of time, the economy will recover from this, and salaries with time will go back up. Once they're back up to what it was before the reduction happened, then it's absolutely fine, and the whole period would then be at the higher salary. But just for that period where perhaps there is going to be a difference between the pre-reduction salary and the post-reduction salary, you would ring fence the gratuity for the period before salary was reduced.
Great, thank you, Sarah. Can you hear me again, or?
I can hear you better. It's a little bit breaking up, but I can hear you a bit better than before.
All right, someone is asking us, I'm typing the question as well. In case of temporary salary reduction, do we need to register the addendum? And in case so, how to comply with the WPS requirement?
Okay, so in case of temporary salary reduction, do you need to register the addendum? And then is there a WPS requirement? Now, if it's a temporary salary reduction, my understanding is the addendum should be completed, and a copy should be available, should be given to the employee, and a copy kept within the business. But because it's temporary, you don't have to register it with the ministry. In terms of the wages protection system, so the WPS, there has been no official announcement, but it is my understanding that the rules about WPS may be relaxed during this period, because, following the resolution, due to the impact, the ministry is recognizing that salaries are going to be reduced, and that employees might go on unpaid leave. Now, it has also been within the past, let's say seven months or so, over 6 months, towards the end of 2019, the ministry also announced that with regard to WPS, it is possible for up to 30% of employees to be paid outside of the system. And that really was a recognition at that time that, a lot of people get seconded into the UAE. They might be on international assignment, and so part of their pay is actually being paid outside of the UAE. But yeah, so my short answer is, for a temporary reduction, you don't need to register the addendum, and WPS should not be an issue during this time, because I think the ministry is recognizing the different measures that employers are going to have to take.
Sarah, I'm getting this question a lot. Can you clarify whether all that we're discussing also applies to free zones?
So as a matter of technicality, the ministerial resolutions don't apply in the free zones because the free zones are governed by the free zone authorities. But my understanding is, and when we've made inquiries with the free zone authorities, they have said that yes, they do expect their licensees, so businesses in the free zone, to do what the resolution says. So try to do things other than dismiss people, even though COVID is having an economic impact.
All right. What about a reduction in working hours? Is there anything around that? And so is it just simply you work less, you're paid less, and it's therefore tied with salary reduction?
So that is interesting because the resolution, when it's referred to reduced pay, hasn't linked it to necessarily reducing somebody's work hours. Now, in practice, a lot of employers are doing that. So they're saying, you know, before we were asking you to do a 5-day week, we now want you to do a 4-day week, and so we will adjust pay by 20%. Now, where it's being done like that, at least in the examples that I'm aware of, that's a temporary thing. It's sort of being done on a temporary basis until things get back to normal. But it is possible, and there are some businesses which are doing this, simply agreeing that employees will still do the same amount of work, but for a lesser salary. It really, I suppose, depends on what you present and what you can get your employees to agree to. And also, you know, whether the economic impact is that there is less work and therefore less need for people to do full-time hours, or whether the economic impact is, you know, cash flow is a bit of a problem. So the work is there. It's sort of getting paid from suppliers and being able to pay suppliers, I suppose.
The resolution 279 says that commitment to employees must remain the same in terms of housing and entitlement. What does this mean, and how does it apply? So do we still need to pay for accommodation, housing, and those types of benefits when the employee is on unpaid leave?
So this really is the ministry seeking to protect, let's say, the most vulnerable, or, you know, those who are not on high packages or even, you know, moderate packages. And what this is really is for workers who typically are provided with accommodation. What this means is if they are on unpaid leave, they have the right to still have the housing provided. So there has been a lot of debate about this. I know there have been lots of queries about, well, I don't give housing, I give a housing allowance. And so does this mean I have to keep paying a housing allowance? And the answer is no. The resolution specifically refers to housing. So it's only if you're providing housing. One thing actually to add is, yes, you have to provide housing. And of course, you have to provide private medical insurance. So that obligation continues.
Yeah, so like you said, the majority of people who will be affected by salary reductions and these types of measures are expats, and whether Western expats or more vulnerable expats in more vulnerable jobs. Of course, for them, it will not only be very challenging to survive financially, but also to relocate in consideration of the travel restrictions. Are employers under any obligation to keep employees under their visa, for example? Sorry, everyone, I'm typing the question to Sarah Khoja.
Okay. This is really a practical problem because the UAE has closed its borders. Now, there are some flights that are operating from, you know, obviously from the 6th of April. But there are many people who are here who won't be able to get on those flights. And so I think on a practical basis, employers really need to, I suppose, think about it from a humanitarian perspective as well. Now, unless it would be, if you look at it from the humanitarian aspect, it would be possible to agree with somebody to go on unpaid leave to maintain their medical insurance, and then the sort of cost to the business greatly goes down because you're not having to pay wages and so on. And medical, typically this is paid for a year. The renewal is paid for on a yearly basis. So you may already have paid this cost anyway, and have people covered under the policy for until the end of the year or whenever it is. There might be still quite a long time to go. So I think on that aspect, it is, employers should be encouraged to think about it in that way. Having said that, I am aware that immigration is still processing visa cancellations. So if you did terminate somebody's employment, as far as I'm aware, certainly when we checked last week, visa cancellations were still being processed. And then the individual could potentially apply to go onto a visitor or tourist visa if they are, they still need to remain in the UAE and they're not able to leave. My advice would be, where you are doing a salary deduction, to always try to only do it from, I think, the allowances, just because of the gratuity point. So you lessen the impact. Now, for some businesses, the impact is so serious that actually, they can't go into that granular detail of chopping a bit here and chopping a bit there. It sort of needs to come off the whole. But if possible, my advice is always to try to deduct from allowances rather than touching the basic.
All right, we'll take one more question on this topic. Tyler here is asking, if we put someone who is on probation on unpaid leave, would this mean that we should extend their probation period even if they pass 6 months?
So that's a very difficult one, actually. It's very interesting because probation can't be extended. So even if you put somebody on unpaid leave, probation, strictly speaking, shouldn't be extended. I suppose in that instance, unfortunately, what the law is encouraging is that you have to terminate them, because probation is the window where you can potentially terminate without liability.
Yeah, you need to unilaterally terminate. If, as employers, we have made job offers prior to the outbreak that, due to the current situation, need to be withdrawn, are there any consequences or risks associated with this?
There can be, yes. If you've made an offer, the person has resigned employment in order to accept, well, the person has, typically they've accepted, they've then resigned so that they can join you. They have acted on the promise of employment, and so they're now out of a job, unless they can go back to their employer and persuade them to sort of continue the employment. So there is a risk, because until they start, they're not under probation. So the sort of window of using probation doesn't apply until actually somebody starts with you. So there is a risk. Now, you'd have to check, you'd have to be sure that your contracts are made subject to, for example, securing work permits and residency, and subject to, other conditions. Now, the UAE has closed its borders, and so you're not allowed to recruit from outside. The ministry has been very, very clear about this. They won't grant any sort of first approvals for somebody to come from abroad. What you could, and so yes, there is a potential risk for somebody when you're going to withdraw an offer. What I would advise is to look at giving them notice of terminating the contract and withdrawing the employment.
Great, thank you, Sarah. So, of course, almost all of the questions that we are getting are around cost cutting and managing budgets while managing people. And we do want to say, as a CIPD, that we understand most of you here, you're almost 200. So sorry if we're not taking all the questions, by the way, but are people professionals and L&D professionals, and as such, you're on the front line of this crisis. So we appreciate those who are going above and beyond to protect employees, and it's really important to not only remember the legal obligations that you have towards your employees, but also the duty of care that you have. And although it is very easy to say and very hard to do, consider broader implications such as the workforce needs that you will have post-crisis, the implication potentially on the employees that are remaining in terms of mental health and well-being in general, as well as other areas that might be blindsided by this crisis, such as diversity and inclusion, for instance. So we are calling on employers to try and make reasonable decisions, but of course it's a very challenging situation. So unfortunately, we're now hearing a lot about redundancies. A lot has changed since we first spoke a month ago. In fact, a month ago when we chatted about redundancies, it was not clearly defined by the law at all. This has changed with the resolution 279, I think. Can you tell us a little bit more about what is being said around redundancy and how it is defined in the UAE Labour Law today?
Yeah, so I would say the resolution has changed it a little bit. I mean, it still remains the case that the law doesn't have a concept of redundancy, so it doesn't define it and make clear, what is a redundancy and how do we apply it and so on as employers. But I think what the resolution has changed is that it said, there are all of these things where you are suffering economic impacts that you can do, reducing pay, leave, unpaid, and so on. Now, I guess one of the biggest things for employers who are looking at terminating employment now is they do need to be a little bit careful that they have thought about all those other measures they could do instead of terminating employment. Because I think with what the resolution is really trying to do, and it's sending a strong message to employers and employees, is we would like the private sector to avoid making terminations at this time. Which is why we're recognizing all of these things. And so employees, to take note, the government is actually encouraging employers to do this. And then to employers, well, if you do go ahead and terminate and you aren't doing any of these things, you will need to explain, for example, if it goes to a labor court and an employee claims arbitrary dismissal, well, why did you move ahead with termination? And why did you not consider any of these other measures? So I think that's another layer to somebody's claim. But again, the actual compensation for an employee is still the same. It's 3 months full package, so it's gross, if they are successful in saying that the decision to dismiss them was unfair.
Yes, because what we could fall into is setting a precedent, which then could say, well, is not having business just for a couple of weeks or a couple of months reason enough to lay off your entire workforce? Or
yes, and especially because, COVID was, the impact of it was so sudden, and lockdowns were quite sudden. And so, once these sort of restrictions start getting lifted, yes, there'll probably be a period of time where it takes a bit of time to get back up to what it was. But yeah, it does. There is a belief that these things are, it is only a temporary thing.
Well, we certainly hope so, all of us. And I hope to soon be in the same room as you, definitely. So if we must lay off employees, then the same obligations as usual apply, i.e. 3 months, the gratuity, the end of service benefits. I have 2 questions. One from a few people here asking, is it 3 months basic salary or full gross salary? And the second question is around customs and practice. So if traditionally an employer has offered above and beyond in terms of the package that they offered to the people that were previously laid off or that left the company, are they legally binded to that? And could an employee potentially claim these benefits if they weren't receiving them right now?
So past practice unless it has been, well, there's two things. So unless it's a written policy, then no, it's not binding. If it's not written, then the issue is, well, how well known is it? Is it that, you know, people know about it in the sense that they can rely on it? Or is it sort of, someone is whispered in my ear that, you know, 2 years ago, somebody got the 3 months and about, you know, 5 people have had it in the past. If it's that sort of thing, then no, it's not something that's certain and that you can rely on. If it's a policy, then yes. So I would say that past practice generally is not something an employee can rely on to then come and insist, oh, you know, you always give people 6 weeks or whatever it is, so you must do that for me.
Yeah, and then again, if you did need to fire or let go of some employees, now would be an appropriate time to try and do so with the employee's consultation and consent, and perhaps try and go above and beyond or find an agreement in the timeline, or even if it's just extending the visa, or find creative ways to maintain that employee relation and minimize the impact on the employees as well.
Yes. Yeah.
So I'm going to get to the audience a little bit. I think in the new resolution, there was something around, if you are letting go of employees, you must register them on that virtual job portal, was it?
Yes.
Can you tell me more about that and how it works?
Well, to be honest, we're all sort of finding out now how it'll work. There'll be a lot of kind of practical issues that come up, but it is, setting aside for sort of employment geeks like me, it is quite an exciting development because it's now a kind of a portal or an online system where individuals can register or your employer can register you, and you can go out and find jobs elsewhere. So, for example, as an employer, if you put a lot of people on unpaid leave, you're still providing them with the housing and the medical care, but obviously you're not paying them a wage. You can register them on this system and then make them available for any other employer or company who needs people. So one example that I'm aware of, hospitality has been very badly hit by this, and they were actually contacted by a food producer saying, I'm incredibly busy and actually I could use some of your people. So it's allowing a little bit of flexibility. And so yes, if you've put a lot of people on unpaid leave or even reduced pay, significantly reduced pay, then you can put them on the system and allow them to go out and make up the difference in salary.
Great. So again, going back to what you've highlighted several times, but really important, that new resolution that says employers are strongly encouraged to put gradual steps before getting to redundancy. So it goes to implementing a remote work system, granting employees paid leave. What we've also seen with Clyde Co is that if an employee were to not have paid leave balance, you could also consider things such as letting them borrow leave days from the subsequent year to avoid impacting them, if that was at all possible. Or asking them to take unpaid leave and even that out in the pay to the year after, so that they're not finding themselves with 6 months of unpaid leave in 2020, for instance. Remote work, paid leave, unpaid leave, temporarily reducing salaries, permanently reducing salaries, and eventually redundancy. And as we've seen with Clyde Co, I think the UAE Labour Law is very much reliant on evidence, and so strongly recommend that is documented. Is that right?
Absolutely, yeah. If it's not documented, it's a strange thing, but it will be as if it never happened. I think it's a good way of describing it.
All right, we're happy to take a few questions before we move on. Are the employees registered in the MOL job portal being prioritized by companies or even other normal job over normal job seekers? So is there, together with this job portal, is there a form of prioritization?
I don't think there is formally, but I think in practice, because recruitment from outside of the UAE is closed, so you are having to look at people who are already here. If you are, my understanding is also, if you are an employer that is covered by the Toteen Gateway and the sort of Emiratization program, which not everybody, but many employers are covered by, due to the reduced hours and the remote working and so on, I think it is difficult at the moment to be to get put on an open day where you can then go and present to potential candidates, UAE nationals, to then open up the system for a foreign national. So I think if you are an employer who is in that category, it's actually going to be very, very difficult for you to get somebody other than through the virtual labour market.
Yeah, absolutely. We're getting a few questions on the question of extending the visa. So we know this is a great area, but potentially in today's circumstances, you were to let go of someone and wanted to offer them to stay on residency visa. What does the law provide for this, or does it even at all?
So it doesn't talk about it expressly. There are, I suppose, two ways of doing this. One way is you are going to terminate somebody, so you give them notice, you pay them for their notice period, and then you put them on unpaid leave, following which, once things become clearer, once flights start operating again as normal, you then cancel the visa, pay out the final entitlement, so the end of service gratuity would be the main thing, and then you process the visa cancellation and the person leaves. That's potentially one way. The other way is you sort of time it. Now, of course, the difficulty here is that we just don't know when flights are going to start operating normally. But for example, if somebody's on notice of at least a month, we are in April now, you would give notice which would take them to mid-May. Then you can wait 30 days before you present the visa cancellation, which would take you to mid-June. Once the visa, in my example, is cancelled in mid-June, there will then be a 30-day grace period, so which would take somebody up to mid-July before they actually have to leave. So there are a couple of ways of looking at it. And another way is to serve notice, pay out the notice, and then have them on unpaid leave, where they can go onto the virtual portal and maintain the visa until you're able to cancel it.
Yes, because effectively unpaid leave, they will still be on your residency visa and you're not paying them at all, which is as if they were not working for you.
Yes. Yeah.
All right. So again, home working, which is the first of these steps that had to be taken. A couple of months ago, it was. I remember seeing a Gulf Talent survey where, we were seeing that a third of employers were considering having their employees work from home. Obviously, the reality has changed drastically since then. On the 26th of March, Emirati issued a resolution for all private sector employees, whereby only 30% of the workforce should attend the workplace except for those sectors. Can you chat, is there anything, so there was that, there was also the limit to customers that can be in premises at once, and the limit on the of employees that can be in shared transportation for those sectors where you may have workers. It didn't seem to provide for shared accommodation. So is there anything around that? And is there anything else to highlight on the topic of home working that has changed?
So with home working, there's just been a sort of guidance as to if you have somebody working from home, then being very clear with them what the expectations are. So the resolution that talked about reducing 30% and 70% working from home and so on also had an attached sort of protocol where, as an employer, you should make it very clear to employees, if someone has to log on, what hours are you going to ask them to log on? Is there a concept of core hours, or are there certain deliverables? And sort of being very clear with employees about expectations. Also, equipping employees to work from home, so that they have a laptop, they have a printer if they need it, all of this kind of stuff. and making sure as well that the workplace is a sort of safe environment. So I think employees also need to be told, position your laptop in a place where, your bookcase isn't going to fall on it, or something like this. Your wires are sort of adequately, pushed away and in the right place. So I think employers do have to put in these kind of protocols. And I think actually one of the most interesting things about this is that even when we see some of the restrictions being lifted, we are likely to see for quite a long time employers doing a combination of getting people to come back into the office gradually. So there will be I think for the next year or so, there's probably going to be quite a significant group or proportion of employees who are going to work from home. So I think these kind of behavioral protocols are going to be very important.
Yeah, absolutely.
Actually, I did want to mention, just on, because you mentioned accommodation, and this is quite important, because the Ministry of Health and the Ministry of Labour have published guidelines for accommodation where it's employer provided. And this does talk about, increased cleaning, sanitation, and distancing. So, maybe closing some of the common facilities, having so many people in sharing rooms and so on. So there are revised guidelines to take that into account.
When you say guidelines, are these legally binding, or are they?
Yes, I mean, they are. So they are issued by the Ministry of Health and also the Ministry of HR, and they are binding on employers to comply with them.
Sorry if you can hear the call to prayer behind me. I'm close to them. All right. So you've raised the question of health and safety at home. So obviously, in a normal environment, employers have certain obligations when it comes to health and safety for their workplaces, ensuring that everything that you said about electricity and water and for sitting, etc. To what extent do these obligations extend to homes, them now being the workplace?
I think so. This is really interesting, and I think it does because I don't think the entire home. So if you live in a villa, your whole villa is not a workplace now, but sort of your desk where you are working, it is now your workplace. And I was told by a colleague that she had some employers saying, well, does this mean that I should go and visit my employee and have a look at where they work? And I think that the answer to that is probably no. You don't need to do that. But I think, yeah, you do need to tell people you need to, have a proper place to work. You need to be keeping your laptop secure, closing it or locking it so that not everybody who's sort of in your home can see it and review things. Being more careful about not letting somebody else use it, because obviously it'll have confidential information. So yeah, I mean these things are important. Yeah.
Yeah, and there are also considerations around data protection. Obviously, you may be letting your employees taking confidential information that they would not normally take out of the office.
Yes, yeah, and so if you put in guidelines as to if you take it home, you have to bring it back to the office to be shredded, or things like this. Yeah.
All right, and there, I guess the usual provisions around a confidentiality agreement that you might have in place, and all of that would still apply.
Yes. Yeah. Absolutely.
Now, if
the other thing, actually, sorry, one thing I've mentioned, Charlotte, that I've just thought about is checking your insurance policy. So I think as an employer, we tend to take out, I think, workman's insurance, third-party liability, medical insurance. So I think it would probably be a good idea just to check workman's insurance for anybody who's working from home, because obviously the workman's insurance is designed to cover, if someone has an accident or something like that.
Yeah, absolutely. And so this takes us to I'm sure something that we're going to see arise is what if I get injured while at home, and home being my office? So whether it is breaking a leg or potentially contracting the coronavirus while working at home, could employers be liable for this in any way, shape, or form?
I think it would be difficult for the employer to be liable, and I've actually had these discussions with some of my insurance colleagues, and our conclusion was it will be difficult because an employee, in order to kind of claim those kind of things, needs to show the connection or the nexus with work. So, for example, if a laptop, I don't know, blew up or something like that, then yes, you know, there would be liability because that's a piece of equipment provided by the employer. But if, for example, at work, you know, very sadly, you came in contact with somebody else who is a colleague or a friend or a, you know, just someone who comes to visit and got COVID, then that would not be a work-related illness.
So on that, we've all heard about the fines for transmitting COVID, which I think is the law on communicable diseases. How do these apply and relate to employers potentially?
Yes. So this isn't so much on the home working. I think it's where you are operating a physical office. Now, obviously, in Dubai, that has become much more difficult given the 24-hour curfew that we're currently under. But in the rest of the Emirates, obviously, it's still relevant.
But this could still be the case for employees in supermarkets or delivery or employees that are about. Very, very true, yes. And financial services, so, you know, banks are allowed to operate from 8 till 2 and so on, those kind of support sectors. So, so I think that's where it's important that you've put in place, you know, taking masks, sort of, you've made available masks so that people can wear masks, sanitizers, all of this sort of thing. Yes, that then becomes relevant for sure. So if somebody, you know, is in an environment where that, you know, they're not able to do social distancing, then you can be liable as an employer. Yes. Okay, that's really important. So that means that even for those who are operating in offices or in physical places, it's really important to ensure that you let them wear gloves, masks, and take temperatures in premises wherever applicable, and that there is social distancing because you could be held liable. And what does it mean to be held liable? What could they sue you for?
So yeah, I mean, as far as I'm aware, COVID, although it's been added to the Communicable Diseases Law, it hasn't, as far as I'm aware, been added to the Labour Law in terms of an occupational health, you know, disease or condition, and so the law isn't very clear about the fact that you can have liability as an employer from a sort of workman's compensation perspective. But generally, under the Civil Code, anybody is liable for the harm that they cause. So if an employer hasn't taken steps in the workplace to protect employees, that is potentially a civil claim that employees could bring for the harm caused.
Great. So can everybody hear Sarah when she's speaking? Because I'm getting a few comments that they can't. Can you hear Sarah's answers? Yes. Okay, great. So on the topic of home working, we saw your daughter come into the screen just a few months ago. But this is what it is today, and I think that goes, you know, beyond the labor law situation. It's really important to remember that everybody is being asked right now to completely merge their personal life with their work life, and that this comes with challenges. And so as employers, it's important to think, well, look after yourselves, but also thinking of ways in which you can be flexible, perhaps on timings, but on arrangements, even though working from home isn't necessarily flexible right now, it's an obligation. So what can you do to support perhaps parents or people who are having a harder time mentally or physically? And the last point, I know we got so many questions on that, was around performance management. So of course, under the UAE law, you can make people redundant if it has to do with their performance. that means that as employers, you have to be very clear about the expectations, and we are getting bombarded with emails and questions about how do you manage performance while employees are working from home. So now is a good time to look at goal setting, and that would be the topic of a whole other webinar. Stay tuned for that. All right, so we just have one more thing to go through, which is two more things, which is, first of all, data protection, real quick. If an employee contracts COVID-19, should we let the whole workforce know, because perhaps they might have come into contact with that person?
Yes, that's a really tricky one, and I've actually had a couple of organizations where that's happened, and of course they have to be very careful because they have an obligation to the employee to keep their condition private. But then obviously, and I think I would probably be the same. If you hear that somebody has it, you want to know who it is because you might have been in the same room, shook hands, and all of this kind of thing. So I think as an employer, it's a balance. There is, outside of the DIFC and the ADGM, there is no, let me say, comprehensive data protection law. We are expecting there to be a federal data protection law quite soon, but as of yet, as of today, there isn't one. There are lots of different laws which have this principle of confidentiality. So what I would usually say is, if somebody does test positive, you then do need to consider who it is you tell, because if they've come into contact, you do have an obligation, the sort of tracing principle. If they maybe have passed it on to anybody else, then you would need to think about telling those people so that they can go and get tested. Because otherwise you are then potentially helping, I suppose, to perpetuate a sort of super spread of COVID. And so I would say that, I would think with that you need to kind of sit down and think about a list of people who then need to be told, you may have come into contact with somebody, go and get tested. And I've got a couple of examples where clients did that only for the group in which that person worked. And luckily, out of the whole group of whatever in this example, nobody tested positive, so it had a happy sort of conclusion.
Yeah, some could say that spreading such news or broadcasting the fact that an employee contracts the virus could be a damage to their reputation, as they could be seen as the one who gave it. Although we're seeing more and more of so many different groups, and it's really hard to trace back. But could an employee potentially, in line with what you're saying, file a defamation claim if their employer were to broadcast that they the fact that they the virus, and that of course they could prove that they've had a damage on their reputation?
I mean, in theory, yes. So I think I wouldn't, no employer or nobody, no individual should be, I suppose, making a very general public statement. But I think that has to be balanced with the employer's obligations towards other employees. And so if it's happened, if it's happened at work, you are aware of an employee who has been attending work and therefore coming into contact with other employees. I think you do have to tell a select group of people so that they can then go and be tested. And there is obviously this obligation under the Communicable Diseases Law, which is very serious. So the penalties there potentially on the direct supervisor, so not just the general manager or the person who's responsible for the business, but actually, the direct supervisor of the employee could be liable, even criminally liable. The law refers to imprisonment, but doesn't say, whether that would be for 2 months or 3 months or whatever.
So sorry, what you must do then? It's reporting to the health authorities and ensuring you are doing everything that you can to ensure that the immediate circle gets tested at least, right?
Yeah. Yes.
Okay. Finally, immigration restrictions. I know we've had quite a few questions, and I'm sorry to let you wait until the end of this webinar for this. I think there is not much use to talk about travel restrictions at this point. There is not much travel going on at all. And now it may be a while before we can even bring anybody from abroad into the UAE, as you said, what could the immigration restrictions, what impacts could the immigration restrictions have on UAE businesses?
So I think that the messages from the government are clearly designed to prepare people for having quite a long period where they will not be able to recruit from abroad. So they will, have to recruit from the local pool of talent, because I think they are not going to lift the restrictions on bringing people from outside into the country. It may, for quite a long period of time. I do want to say a year because that's purely me speculating. But I think what we've seen is even when these restrictions start to get lifted internally in the UAE, there's a fear that if you then let people come in, there'll be a second wave and of COVID and infection and so on. So I think from an immigration perspective, the messaging from the government is that this is going to be a long time where, let's say maybe 6 months at least, where you're not going to be able to bring people from outside into the country. So I think the people who are here could potentially have a very high premium once everything starts getting going again.
All right, so we're going to see a lot more poaching, which also means that employers are careful of things like non-compete agreements, etc.
Yeah.
I keep getting questions about teachers. Is anything different for teachers? Am I missing something? No? I had a few people today that kept asking if this applies to teachers. So, yeah, all right.
Yeah, I mean, all of these... sorry.
Go ahead.
So with teachers, all of the labour rules apply to teachers. There are, alongside that, some protocols from the KHDA in Dubai and sort of the Ministry of Education on a wider federal level. So there are special rules for teachers. Very often they're expected to give, early notice, so a full term notice if they want to leave, or they don't want to renew their contracts and so on. So there are additional rules, but these rules still apply to everybody, to teachers as well.
Yeah, we fall under KHDA, and there are a few more regulations, notably around hosting classes, courses, events, etc. All right, the last question on immigration. Some people might have been stuck home, whether they traveled prior to the flight being cancelled or whether they were away on a business trip, which is impacting their work and they're not able to come back. Is this reason enough to terminate? And can you cancel a visa, end a contract if the person is not able to get into the country?
Possibly, yes. It really depends on a sort of case-by-case assessment. So if they're outside, are they able to work remotely? Because, well, chances are if they were here, they'd have to work remotely. So, can they do that whilst being outside of the UAE effectively? If they can't, can you then, going back to what the resolution is saying, can you put them on unpaid leave or reduced pay or, something like that? And then, of course, I guess if you can't do any of that, you potentially could move to dismissal, because we just don't know when the travel restriction will be lifted. There have been some people who've been allowed back into the UAE, but it's been really exceptional. And it's been on the basis of sort of emergency or humanitarian grounds. So, the example that was in the papers was a sort of a young child who'd gone off to visit grandparents in Germany and then was allowed to come back to be with the parents who are still in the UAE. So it's really exceptional. So I think if somebody's outside, potentially, yes, you could move to termination. But again, we go back to looking at whether they can work remotely, whether you could put them on unpaid leave for a time, or reduced pay. Now, one thing the government has said, because there's always been this rule that if you're outside of the UAE for 6 months or more, your visa becomes invalidated. And the immigration department has said that they will automatically renew visas so that they shouldn't become invalidated.
All right, I think we've covered quite a lot in this session. We've just kept it to 1 hour. So I just want to give it 5 minutes for you guys on the other side of the screen. Do you have any questions on immigration, paid leave, unpaid leave, sick leave, anything? Please let us know. And we're sorry that I'm not picking them up all. But like I said, you're about 200, so I just pick what I can see as the threads go down, which is great. Thank you for joining us. Does anybody have any?
Charlotte, I can see a question that's been asked quite a lot, which is, can salary be reduced during notice period and without mutually agreeing? So my answer to that is no. If you're going to reduce salary, it should be agreed. Now, during notice is interesting because if you are going to serve notice, then it's the normal pay that applies. And so during notice, one would expect that you'd pay them as normal because, you know, the notice, you're terminating employment. And definitely not without mutually agreeing. Yeah.
Great. Is it still possible to transfer between employer visas at the moment? If I am due to start a new job but my date of joining has been deferred, can my existing employer cancel my visa?
The short answer to that is yes, because if you've given notice, then your existing employer period, and then they could cancel the visa. As far as I'm aware, visa cancellations are still being processed.
A question: if you're sent on unpaid leave, should employers pay home and food allowances? So I think that was really important what you said, Sarah, earlier, is that this seems to apply only if you're providing in kind and not necessarily for allowances.
Yes, yeah, that's right. That's right. So the duty to continue is if you actually provide housing.
All right. So if you provide in-kind housing, you must continue even in if on unpaid leave. But if it is a housing allowance, which presumably is part of the salary, then you don't have to pay for that.
Yes. Yeah. Yeah. Agreed. Yeah.
If you're on unpaid leave, do you get paid if there is a holiday? And while on an unpaid leave, do you accrue leave days?
So that is interesting. So if there's a holiday, then no, because you've agreed to be on unpaid leave for the period. Do you still accrue holiday? Well, the law isn't clear about this, to be honest. The law is very clear that during any period of unpaid leave, you won't continue to accrue or earn end of service gratuity. So any period of unpaid leave will not count towards end of service gratuity. It doesn't have the same very clear statement about holiday. Most employers would maintain that during unpaid leave, you're not accruing any other leave. But I have to say the law is not as clear as that. It's very clear about end of service gratuity, but not clear about the holiday.
So then perhaps there's also an opportunity for employers to fill this gap and see what they might, I think we lost. Is anyone hearing Sarah?
Oh.
Ah, you came back.
Yes? Okay, good.
Sorry, we completely lost you there.
So I was saying that the law is very clear about gratuity. Doesn't accrue during unpaid leave. It isn't clear about annual leave. But most employers, many employers will maintain, well, you don't accrue gratuity and you don't accrue any entitlements. But I have to say the law is not very clear about the annual leave.
Yeah, so perhaps there is an opportunity here for employers to also fill that gap and look at whether you want to give that opportunity for employees to maybe accrue paid leave for the future. All right, the question that we got the most, and that will be our final one really, is around paid leave, unpaid leave. So can you put people on paid leave? Can you demand that your employees, I learned that asking and demanding are not the same things, especially not in the law. can you demand that your employees take their annual leave, Sarah, even if they don't have balance? So if they don't have balance, it's unpaid leave immediately.
Right. So so if they have annual leave, then yes, you can demand, because you can, if you're right as an employer, you can just say to somebody, we now are in a situation where I need you to take your leave. You'll be on leave from the 1st of May to whatever it is. Now, if they don't have a leave balance, then that is more difficult, and you would have to agree the unpaid leave with them. I have to say, given the resolution from the ministry, many employers are, I wouldn't say they're, I wouldn't say they're demanding, but they are more or less, the approach that they're taking is informing. So they're sort of telling everybody, or, you know, this is the way it is. We will need you to take unpaid leave.
And is that okay?
I think in terms of an approach, it is okay in terms of telling everybody the same message and a consistent treatment. I would say that you do need to still have employees sign in agreement. So their addendum or any kind of note saying, yes, you know, I received your notice and you know, agree with it.
All right, and the final question, paid leave on reduced salary. So I'm assuming that if you have agreed a reduced salary, which has now become your current salary, if you're on paid leave, you will be paid your reduced salary.
Yes, correct.
Yeah. All right. All right. Thank you very much, everyone, for attending. We hope this has been a useful session. That was the CIPD in partnership with Clyde Co. My guest today was Sarah Khoja, partner at Clyde Co. Together, we host a UAE Labour Law course and a Saudi Labour Law course, which we will link in the email that you will receive after that. We continue hosting webinars, so please stay posted and follow us on social media. And finally, I do want to ask you, employers, sharing practices is more important than ever to help the market and help other market players know what is going on, or perhaps think of innovative ways in which they can tackle the situation. So if you or your organization are putting in place anything around health and well-being, or finding new ways to not get rid of people, reskilling, or restructuring your business, and have an initiative worth sharing, please do let us know. You can contact us at events@cipd.ae. And we really hope to hearing from you soon. And finally, we have the campaign HR Together, which was launched in partnership with CIPD UK. It's a global campaign. We want to shed light on the great people in the people profession doing amazing work. And so if you want to nominate a colleague who is doing outstanding work supporting their employees right now, please, again, let us know on social media or email us. Stay safe, everyone. Stay home. Thank you.
Thank you.